Thank you, everyone, for joining. Good afternoon. I want to repeat my thanks to Deb King, to Chloe, to Chelsea, to Michael for making all of this possible. I know that we could not have pulled together this event without you, and we're really grateful. And to also all of my fellow members of the Sentencing Commission, I am grateful and honored to be a part of these very important conversations that are happening with all of us here in person today, which is a real privilege. My name, as Dean Nelson mentioned earlier, my name is Anna Van Cleve. I am the director of the Criminal Defense Clinic here at UConn, also an affiliate with the Center on Policing, Public Safety, and Inequality, and a member of the Sentencing Commission. I'm honored to be here with our panelists to address the topic of felony murder. This has been an issue of increasing importance in conversations about criminal justice across the country. The basic principle is well known to lawyers and taught in the first year of law school. The idea that a death that occurs in the course of a felony can be prosecuted as murder, even where an individual did not intend for that death to occur, and even in some cases where the individual did not directly cause the death themselves. Critiques of the principle have long been raised, namely that it undermines important principles of mens rea in criminal law, that its effects are harsh and can be disproportionate to the level of culpability, that it has been a driver in the rise in extreme sentencing across the country, that it targets vulnerable populations, and that it has racially disparate effects. The topic became an issue in national politics recently, in electoral politics in the lead up to the midterm elections, and it was the subject of a recent report that was issued jointly by the Sentencing Project and Fair and Just Prosecution, an organization of current and former state and federal prosecutors. The Connecticut Sentencing Commission has also begun to study the issue here in our home state. In light of this background, we are very fortunate to be joined by our panelists, and I'll give brief introductions before I turn it over to each of them. First, we have Nicholas Aponte. Mr. Aponte is an advocate with the Fair Chance Licensing Project, working to eliminate barriers against professional licensing for people who have been convicted of crimes. He was convicted of felony murder and sentenced to serve 38 years in prison. He was unanimously paroled after 23 years of incarceration, and he works as a certified nursing assistant and a real estate office manager. Giora Binder is a SUNY Distinguished Professor and Hodgson Russ Scholar at the University of Buffalo School of Law. He is the author of the book Felony Murder, and his work on felony murder has been cited in numerous court decisions on the issue. Eko Yanka is the Thomas M. Cooley Professor of Law at the University of Michigan. His work focuses on issues of political and criminal theory and questions of political obligation and justifications of punishment. So with that, I will turn it over to our panelists, and we'll start with Mr. Aponte.
I'm grateful to be here. It means a lot to me to be able to share my experiences, and I usually try to take every opportunity to be able to try to reach as many people as I can. As Anna mentioned, I was convicted of a 1995 crime of felony murder, me and 3 other individuals. I wasn't the principal offender, but I was, connected to the crime, through the legal aspect of criminal liability for another person's acts. Ultimately sentenced to 38 years, and it was a very difficult time for, someone like me to even understand culpability and those type of things. I believed what geared me towards who I am now. I was just trying to understand how I found myself in that position, first time being arrested and being arrested for such a, a tragedy. Took a lot of, self-investigation, and then eventually, some people who know my story, I had the opportunity to read some of the victims' letters, and I was able to see that this was an actual real thing, and instead of trying to understand why, I was, sentenced to such a long period of time, and that's what touched me the most, reading the victim's father's letter. And in there, he gave a hint of forgiveness, which I think would be difficult for anybody, maybe including myself now as a father also. And it humbled me, and that propelled me to to take the opportunity to keep learning. I eventually, earned my associate's degree in psychology because it fascinated me, the human mind, especially my mind. I eventually became a hospice volunteer and a certified nursing assistant. I did that for 10 years, the last 10 years of my sentence. And things turned out pretty well. And I was sort of resigned to the fact that because I didn't receive the good time credits that people typically received at one time for the sentence, that I was probably going to be in there till I was 55 years old. I just told myself, just continue to be humble and, see what life brings you. And of course, I'm sure most of you realize that there was juvenile justice reform that gave me the opportunity to be paroled. And, thankfully, I was able to be paroled, and I've been home for about 4.5 years. As Anna mentioned, I took my CNA credentials with me, and I was hired. Somebody gave me an exemption, and I continued to do what I eventually loved to do, was take care of people, because it felt very redeeming to me at the same time. So it was kind of reward both ends, and I can actually earn some income off it. I was also became an office manager for a real estate company, and I did those two, 70, 80 hours a week, just put my work in and loving life. And I eventually became a realtor myself. And I'm just starting up my own company in terms of purchasing properties and, trying to receive some passive income. But, life has been really amazing. I had a lot of people along the way. A support system helped a lot. And I could probably go, I could probably go on, but since I've been home, I've had no difficulties. It was a very easy transition, and I remember walking out, and everybody was like, "How did it feel?" And I was like, it was a chapter closing for me, and it was a new chapter, and my life home has been amazing. I've had a lot of opportunities. I'm actually going to, my girlfriend now is pregnant. It'll be my first child since I had my child 28 years ago. He's 28 now. And I've done very well and very grateful. When I have these opportunities like this, it means a lot to me, because I can't imagine how hard it is to balance retribution and the ability to redeem oneself, but we do live in a society where you are allowed to redeem yourself, and eventually everybody returns. And I know that's bigger than me in terms of trying to figure that out. But when I can share some experience about people who can actually do their best with what they have in there, which was kind of minimal in the prison system, and then come out here and actually show you that we can't wait to, show our worth, and not our worst time that we had at one point. And I know, plenty of men and, women who have done just that. And I can't, they don't have the opportunities that I have, but I would definitely like to speak for them, and they're doing very well out here too. Thank you.
Thank you, Mr. Aponte. Professor Binder?
Nicholas, before I start, so how old were you when the crime took place?
Yeah, I was 17 years old.
And how much time did you serve?
I served 23 years of a 38-year sentence.
So I'm going to help us all dry our eyes with some dry facts about felony murder. So I'm going to talk about, very briefly, about 6 things. I'm going to give you a little bit of an overview of what felony murder is, review some of the traditional critiques of it, a slightly different racial justice critique that Echo Yanka and I have been working on. Talk a little bit about reform efforts nationwide, say the little bit that I know about the Connecticut felony murder law, which is less than probably almost anyone in the room, but just to sort of characterize it from a national perspective in terms of where it fits. And then just say a little bit about some reforms that you could consider here in Connecticut, and My guess is that most of you will be able to think about that question again in much more detail than I can. Okay, so what do we mean by felony murder? Well, it has two main features. It consists of conditioning murder liability on causing death in the course of certain serious felonies, with little culpability towards death, at most negligence. Or it can consist of participating in such a felony in which an accomplice causes death. And so in that sense, the second aspect of felony murder, the accomplice liability aspect of felony murder, resembles, for the lawyers in the room, co-conspirator liability. A second, aspect of felony murder that's very important is that the penalties are severe, including life without parole in some states. Third, so where is it? What states have it? Well, 41 states have the low culpability requirement feature of felony murder. 48 states have some form of the rule imposing murder liability for aiding or encouraging the felony as opposed to the actual killing. The 9 exceptions to the low culpability rule are Hawaii, which requires intent, and then Arizona, Kentucky, Massachusetts, Michigan, New Hampshire, New Mexico, North Dakota, and Vermont. So note that this includes 3 of the 6 New England states. And on this particular question, Connecticut is behind that curve. Okay, now what about some traditional critiques of felony murder? So felony murder, we can look at felony murder from the standpoint of deterrence theory, crime prevention. So it's long been recognized that felony murder does a poor job of deterring felonies because of the punishment lottery argument. Certain punishment deters far more effectively than severe punishment. What felony murder does is it attaches a very high penalty to a very low probability result of the felony. Does it deter the killing? Well, not insofar as it imposes strict liability or negligence, because if you don't expect to kill, you can't be deterred by the threat of liability for it. We can look at felony murder from the standpoint of incapacitation theory. But really, felony murder liability, which is very severe, results in very long sentences, is not necessary to incapacitate dangerousness, because everyone naturally ages out of dangerousness as they mature. And so it can't be, incapacitation can't be used to justify long sentences. More fundamentally, incapacitation is simply the ideology of mass incarceration for its own sake, of treating criminality as identity rather than conduct. And it has aptly been called the new Jim Crow. Third, felony murder, we can look at felony murder from the standpoint of desert. Now, this becomes more complicated, right? So on the one hand, felony murder punishes for murder without culpability towards death. And that seems disproportionate. There's a counter-argument, which is that felony murder is somewhat deserved, felony murder liability, because of lay intuitions hold that wrongdoers are partly responsible for the unintended bad consequences of their wrong. And so when we look at opinion studies, right, psychologists, John Darley, found that mock jurors would impose substantial sentences for negligent killing during a robbery, although much less substantial than many of our jurisdictions do. Sentences in the range of 22 to 27 years. So there is, there's an intuition here that resonates with felony murder, provided that there is, you know, a purpose to the crime that, you know, sort of a bad purpose to the crime in addition to the source of danger. And that requirement of an independent felonious purpose, that's often referred to as a merger rule. But I want you to note that, first of all, even, you know, those penalties are lower than are often required by current felony murder law. And when those mock jurors were presented with a case, with a case like Nicholas's case, an accomplice in the felony who did not kill, they favor much lower levels of punishment in the range of 6 to 9 years. When the victim is killed by someone resisting the felony, such as, say, a police officer, or where the victim is actually a co-felon, mock jurors favored almost no punishment at all. So murder liability for the non-killing participants in the felony seems particularly undeserved. Okay, so these are sort of the traditional critiques of felony murder. I want to add another critique. So felony murder's disproportionate punishment came to be used during the war on crime disparately against members of racial minorities, according to 4 recent studies. So there was a study in Cook County, Illinois, that found that the county's black population faced 27 times the risk of being charged with felony murder as its white population, right? The rate was 27 times greater, and they were 29 times likelier to be convicted of felony murder. There was a study in Hennepin and Ramsey counties, Minnesota. This is the Twin Cities. Found that people of color were 12 times as likely to be convicted of felony murder as whites. In the state of Pennsylvania, a study recently found that the black population was 17 times as likely to be imprisoned for felony murder as the white population. And in the state of Colorado, a study found that blacks, conducted actually by the criminal defense bar there, but using state corrections data, found that blacks were 30 times more likely than whites to be charged and 13 times as likely to be convicted. These are very substantial racial disparities. We suspect, though we haven't yet shown, that punishing people of color for participation, for felony murder on the basis of participation in the felony rather than the actual killing is far more common than you know, for people of color than for whites. And these studies directly contributed to reform efforts in 3 out of the 4 states that I mentioned. Okay, let me talk a little bit about those reform efforts. So recent reforms in other states. Massachusetts in 2017, its Supreme Judicial Court decided Commonwealth v. Timothy Brown, conditioning felony murder on recklessness. That decision was not retroactive, however, and there's basically no executive clemency program for those previously convicted of felony murder in Massachusetts. Maryland in 2017 adopted a merger rule, you know, narrowing felony murder by judicial decision. That was also not retroactive. California in 2018 conditioned felony murder on recklessness for the non-killing accomplices and for actual perpetrators during non-enumerated but nevertheless dangerous felonies. So this was an effort to address this, you know, to create a, if you will, a disparity in treatment between actual killers and accomplices. That reform was retroactive, right? And so there's a complex petition process that's created by the statute. Illinois in 2021 eliminated felony murder liability for killings by those resisting the felony, right? So in other words, by police or victims. And so this limit is called an agency rule. Connecticut has such a rule already. That's not a reform that you need to do. This reform was not retroactive, but in that state, there's an ambitious executive clemency program that was initiated by the governor to review past cases. Colorado in 2021 also adopted an agency rule and reduced its punishment. It capped the penalty for felony murder at 40 years. This was done with the support of many prosecutors. The program, though, unfortunately can't be retroactive in Colorado because of their separation of powers doctrine. And thus far, there's been no executive clemency program. There's some current initiatives going on. So in Pennsylvania, there's a litigation campaign to eliminate mandatory life without parole sentences for felony murder as cruel and unusual punishment. There are also efforts in the legislature to achieve similar reforms. Currently in New York, there's an effort underway in the legislature to condition felony murder on recklessness. This is at very early stages, but to do so for both the actual killer and non-killing accomplices, to cap the penalty for felony murder at 25 years, to adopt an agency rule, which New York now lacks, and to make it retroactive. Let me say a little bit about Connecticut felony murder law and how it fits into this overall pattern. So, as I understand it, that the penalty for felony murder felony murder in Connecticut is conditioned on enumerated felonies only, that the penalty is 25 years to life, and it's conditioned on foreseeability, which is effectively a negligence standard. There's a separate arson murder that has mandatory life without parole. There's an affirmative defense for felony murder for those who carried no weapon and had no reason to know accomplices had a weapon or might kill. You already have in place an agency limit and a merger limit. Okay, so finally, what could you do in Connecticut that would address some of the problems with felony murder? Well, you could join your New England neighbors in conditioning murder in the course of a felony on recklessness. I talked with several people this morning who were unaware that New Hampshire and Vermont even have this reform, right? So why is that? Well, because the reform is equivocal. You can call it by two names. You can characterize this as abolition of felony murder because it's conditioning felony murder on significant culpability, recklessness towards death. You can also characterize it as reform of felony murder. Yeah, we still have felony murder in Connecticut. We've just more precisely defined the mental element. So this can work for whatever your political constituency might be. So you could adopt that reform like your New England neighbors. You could cap the penalty for felony murder and for arson murder at a term of years. As I mentioned, in New York, we're looking at 25 years as that possible cap. You could consider conditioning complicity in killing during a felony on aiding or encouraging the killing, the act causing death itself, not on aiding or encouraging the felony. Right? This would be ahead of the curve. No other state has done this, but it's the right thing to do. You could compromise. You could greatly reduce the penalty for complicity in a fatal felony with reckless indifference to human life. So Wisconsin actually makes felony murder a sentence enhancer to add to the felony. So you could have a smaller sentence enhancement for the accomplices. You could make these changes retroactive. And if you don't make them retroactive legislatively, you could do it through a pardon process. Very important, right? So you can gather data on the racial as well as the age distribution of those charged with and convicted of felony murder. That data is not systematically collected. It's not been systematically collected anywhere, really. You could also look at the racial distribution of those who are convicted of felony murder for actually killing or just for participating in the felony. Data showing racial disparities, which we are confident that you will find, despite the virtues of your fair state, those racial disparities can be an effective argument for reform in Connecticut as they have been elsewhere, including in Colorado, where big city prosecutors were on board and supported the reform, as I hope those of you in the room will.
Thank you, for Professor Binder. Professor Yonka.
So if it's always a difficulty following my friend and co-author Giora, who is without doubt the world's leading expert on American felony law, you know how people toss out that phrase. I mean, this time it's not a close call. If that's difficult enough, following Nick is really, I have to say your story is just remarkable, and congratulations on the soon-to-be birth of your second child. I'll be looking to you for real estate and parenting advice, as you already have a 23-year-old. One of the honors I have is to work on the release of people who have been falsely convicted, and I want to be quick to say that I'm not here as a representative of the Innocence Project at all. But even in that role, one of the things I'm keenly aware of is that our society cannot function if the only people who tug at our heartstrings, the only people to whom we show the decency of reincorporation are those who we accidentally convicted. One of the things that moved me about Nick's story is both his brave but necessary centering of not just his story, but that of the victims as well. I thought that showed remarkable moral maturity. We are well aware that at the other side of all these stories is another lost person, somebody who died. And the fact that we can care and want to reincorporate those who we rightfully punish does not mean we've forgotten the victims either. And I think it is too often a false dichotomy, a sort of cheap shot that it has to be one or the other. Nick has told us why it is that he gets to re-enter his life without having forgotten a person whose life was lost. My first encounter with felony, forgive me, I'm going to do a very quick overview because between Nick and Giora, there's not much more by way of stats and facts for me to present. When Giora's not around, I get to be the expert, but when Giora's around, you just do something else. My first encounter with felony murder was actually as a very young law professor outside of Chicago. And I met a man, he was an older black man. Sorry, it just occurred to me he probably wasn't much older than I am now, but at the time, he seemed like an older black man. Damn. He was a Vietnam veteran. He's a Vietnam veteran who, like many veterans, had gotten hooked on heroin while he was in Vietnam and he'd come back. And he told this story very haltingly with great shame in his voice. The shame was mostly about being a drug addict. He still felt that deeply. So he'd been a drug addict, and one of his suppliers offered him drugs if he would drive to a deal. He had no reason to believe it was anything other than a commercial deal. I remind you quickly that he was quite ashamed of this. He felt he didn't take it casually that he was part of a drug deal. He thought that was a part of his life having gone bad, but it was a drug deal. Most of you in the room know where this story goes. The drug deal went bad. 2 people ended up in a gunfight, and they shot each other with the dealer being killed. Though he thought he was just giving a ride to a commercial transaction, an illegal one, but a commercial transaction, was charged for felony murder and sentenced as a murderer, and spent many decades, or a couple decades in jail, in prison, excuse me, before coming back and speaking to our law school. I tell this story because, though many of you are aware, I think it's really, really important for us to give vivid life to what we mean by the kind of philosophical work I often write in when we say there's a mismatch between culpability and punishment. These are not just abstract terms. It is one thing to say that I deserve to have been punished because I was engaged in a drug deal. It is quite another thing to remind us that the gap between being a driver in a drug deal and being a murderer is vast. It's vast. And that's what felony murder obscures. By a legal sleight of hand shifting culpability for murder for something that wasn't. Whenever I teach my class, I always say, whatever else is true, this person was not a murderer. That's the fundamental mismatch in felony murder. Now, as Gura pointed out, felony murder is not without any argument on its side. I know this room is much more sophisticated, but when I teach my 1Ls, I say, look, there's a kind of understanding we have of felony murder, right? It is, you'll forgive my being patronizing, or no, paternalistic, excuse me, in the true sense of the word. When I teach my children, right, so I have 2 small children, and let me assure you, in my household, things just are mostly going wrong all the time, right? This is what it's like when you have a 9 and a 6-year-old, 2 boys. And the common answer they give back to me is, I didn't mean for it to go wrong. To which we quite reasonably tell them, that's why I told you not to do it in the first place. It is that deep moral intuition that drives felony murder. It is, we told you not to commit these dangerous crimes in the first place because we don't care what you think. We know it goes wrong. The problem is in felony murder, that is not nearly as true as we think it is. So one of the sets of statistics that you'll learn if you read Gura's very, very fine book is how actually rarely felonies accidentally end up in deaths. Now, to be fair, it's much, much higher than the base rate of people walking around, right? If you're not engaged in a felony, you will obviously, it's much rarer to kill somebody. Again, not zero. People drive and get in accidents, but it's obviously much rarer. I don't mean to elide this, but it's also not nearly the case that felonies end up in deaths as they do in the public imagination. It's way below 1% for most robberies, for example. So that these are really truly accidents, such that the culpability gap exists. Moreover, as Gura pointed out, we have ways of addressing cases where felony murder seems appropriate. The kind of cases where felony murder most tugs at our moral intuitions are cases that the law already handles, and I think that cannot be emphasized enough. So the person who starts a gun battle with the police and somebody ends up killed is often a kind of obvious story for felony murder. He says, well, I didn't mean to. And the thing is, as the law already provides for depraved indifference charges of murder, when you do something which is so close to murderous culpability that we say it doesn't matter what you did, felony murder is used in cases where that is already not an attractive line. Forgive me, that was a long-winded way of saying we don't need felony murder for the cases where felony murder makes most sense. Here's where I want to build off in conclusion. How do I know that we don't need felony murder in the cases where felony murder makes most sense? Because as Gura pointed out, we had the pleasure of co-writing an article together, and I want to give my co-author credit. One of the lines I really liked that he wrote, and it's a quiet line, I don't know if he knew how much I liked it. He said, we know we don't need felony murder because we seem to do quite well without it when people are white. Right? That is to say, in the studies that we have, felony murder prosecutions, as Gura just hinted, are overwhelmingly aimed at people of color. And that is to say that that is true even when we control for the same kinds of crime, right? When white people walk into a robbery and something goes wrong, we charge them, as well we should, but we do not charge them with felony murder, right? We charge them as the law already prescribes. It seems to be only when people of color, only is strong, you take my meaning. It seems to be vastly disproportionate when it's people of color that we charge people with felony murder. Forgive me, let me just, and I say this also worried that this understates the problem. The reason is, of course, if it's hard to get the data on when we charge people, it's really impossible to get the data on when we threaten to charge people. As everybody in this room knows, 95% of all criminal cases, probably 95%, it's hard to even know, result in a plea bargain. So we don't even know the way in which prosecutors can use felony murder as a kind of ominous threat that you better plead out to what I damn well tell you to because I have felony murder in my back pocket. And if we know the racial disproportionality that affects who's actually tried, we can certainly imagine the racial disproportionality that affects those who are threatened with trial. I'll just end on one last note. The reason this is pernicious is not just because of the devastating racial effects. Felony murder is actually charged in a relatively small number of cases, and so it's not as though we think there's a direct causation between this and, for example, mass incarceration. But it does build on a very pernicious racial aspect which we should all be deeply on guard against, and one that does infuse our criminal law system. One of the things people of color are well aware of is a kind of penalty of association, right? When one black person does something wrong, it's because there's something wrong with black people. When one white person does something wrong, it's because there's something wrong with him, right? This effect shows in the felony murder case. So one suggestive study that Giro and I have both been reading, we treat it with some caution. It's a new study. It's just coming out, and one doesn't want to treat one new study as perfect proof of something. But the troubling thing about this study was it showed the interaction between felony murder and accomplice liability. And what it showed is that jurors are much, much, much readier to try somebody as an accomplice for felony murder if they're a person of color. That is to say, if 3 people walked in a room, 1 person killed and the other 2 did not, if they were black, we would treat them all as murderers. You all hang out together, you're all guilty by association. If they were white, they were not. Then the murderer was treated as a murderer and the other 2 were not. They were treated disproportionately as having individual culpability. It is that kind of racialized crime by association, tainted from the beginning, as the popular literature often speaks, that we think is deeply dangerous. One of the worries with this study, by the way, was when jurors were reminded of the racial disproportionate effects of the criminal justice system, we then saw the way in which black accomplices were charged dropped. So it seemed like maybe you could track and hopefully adjust for this racial disproportionality. But then a funny thing happened. The moment you reminded them of the racial disproportionality for black people, that dropped. But then their association and accomplice liability for Hispanic people shot up. It's almost as though there was a racial animus that's looking for a place to hide. I don't know what this study will ultimately prove, but it does tell us that our unwillingness to treat people as individuals and to find out for what they're actually culpable, especially when the law gives us the right way to do this, is the wrong way to go.
Thank you all. As always, I always have questions, but I also have many opportunities to ask them. So given the time that we have left, I'd be happy to turn to the audience and see if anybody has questions for our panelists.
Thank you so much for being here. It's a fascinating discussion. I'm wondering if you could talk about felony murder in the context of some of the recent police shootings that we have seen. For example, the case of officers involved in the killing of George Floyd.
Well, you've asked the hardest question, but it's one that we've not just thought about but written about.
It's funny you should ask, an academic would say.
So, like many people around the country, we were profoundly relieved by the conviction of Derek Chauvin for murder in that case, and yet, it was frustrating for us that the conviction was for the crime of felony murder, as opposed to, say, depraved indifference murder or even intentional murder. Depraved indifference murder in Minnesota would have been a lesser charge than felony murder, which we think is perverse in terms of the penalties. It's also for peculiar reasons not available for what Derek Chauvin did. In Minnesota, it turns out that depraved indifference murder requires that the defendant recklessly place multiple people in danger. In the vast majority of states that have a form of depraved indifference murder, that's not the case. You can be liable for murder even if you've targeted just one victim. So Minnesota is unusual in that regard, and for that reason, that charge was, it was sort of, whether it was available was actually under litigation in a companion case, the Noor case, while the Derek Chauvin prosecution was unfolding. So that's one aspect of the case that was that was regrettable. Another aspect of the case is that Minnesota is one of a relatively small number of states without a merger limitation. So the underlying felony in that case was essentially simple assault, right? So assault with a serious injury, but in Minnesota, even that offense, assault with a serious injury, doesn't require any mental culpability towards the injury. So effectively, what he was being punished for was a mere assault, unlawful, physical force that happened to result in death. I think we both think that grossly understates the officer's culpability in killing George Floyd. Now the sentencing of that, the sort of sentencing memorandum read by the judge, recognized the culpability of Chauvin and went into it in detail. That's great, but that's not what the jury was actually asked to find. So it's unsatisfying. The murder result we think is appropriate. The path to get there in Minnesota law was unfortunate.
Let me just add one other note. I mean, so in law school you learn the phrase "bad cases make hard law." In this case, I would say tempting cases make bad law. One of the things that Giora and I spent some time working on is the way in which felony murder, though, look, like everybody else, maybe more than many, watching those videos can undo you. I get it. I really get it. But the temptation to use felony murder to charge this officer also has an effect of obscuring the way in which felony murder usually works in police killings, which is to say, because most states, as Giora said, or because too many states, it's a minority of states, but actually it's a slight majority of the population, doesn't really matter. Because, let's say, almost half the states don't have an agency rule. That is to say, anybody who kills anybody else during the commission of a felony can be, the perpetrators can be charged with a felony. It means that felons are often charged with killings that really look like reckless policing, right? So even though in the Chauvin case, the right person was tried, felony murder in many, many, many cases actually works to obscure police violence. I'll just give one example. Some of you might know about a young Steven Rodriguez who was killed in Oklahoma. It became a very visible case. This is a young man who robbed a gas station, armed with a co-felon. Wyatt Cheatham, right?
He was actually sort of a child.
He's a 17, right?
I think even younger, maybe.
Was he even?
But anyway, a teenager.
He's a very, very young. I mean, from our point of view, from my point of view at this age, he's a child. He's a kid. He's really a kid. He was as old as you were, right? So he walks in a gas station with a gun, right? I mean, This is a terrifically dangerous thing to do. It's not that we don't get that. His co-felon flees the gas station. He's surrounded by police. He's so surrounded, he actually ends up going back in the gas station. The cops are essentially making fun of him. He's kind of hapless, right? They're making fun of him outside. This is all videotape. And finally, they ask him to come out. And he comes out holding a gun. He comes out, he takes the gun with his 2 fingers, and he places it down. There's something like 8 or 9 police officers in front of him, some huge number of police officers shouting conflicting instructions at him. Finally, he moves, and this is all on video, so you don't need to take my description. By moves, I mean something like he flinches the way you might if a lot of armed people were pointing a gun at you. Suddenly a shot rings out, and then a barrage of shots, and he's just killed. He's just gunned down in front of us. Wyatt Cheatham, his co-felon, who was not at the crime, was the one who was charged with his murder, right? It's that young man who is charged with his murder, and the prosecutors did not look at the police at all until the video was released. When the video was released, after sustained protest from people of that city, finally the prosecutors not only dropped the charges against Wyatt Cheatham, but they charged the police officers with manslaughter, right? I don't know if those police officers will be convicted, but that's the right charge. If somebody should be inspected. So the point is, we should be careful not to take the tempting bite of the apple and not notice that. And by the way, the Rodriguez case is just one. I mean, I won't bore you. We could go through case after case after case after case where felony murder is used to obscure egregious police tactics that lead to death because there's a ready and culpable villain you can charge with felony murder instead.
Other questions in the group? Yes.
Thank you.
I wanted to thank you all. Thank you. Yep. I just wanted to thank you all for a beautiful presentation. And my question to you is, what do you think about Connecticut's overuse of the Alfred Doctrine in resolving capital felony murder, and in a lot of cases, regular murder?
Does everybody here know the Alfred Doctrine? Should we say something or? All right, so the Alfred Doctrine, by the way, I rarely know this much law. You know, I'm actually a legal philosopher, so this is very weird. The Alfred Doctrine is, correct me if I'm wrong, but it's to make, people have to essentially admit to culpability for a crime before they're released, even in many cases where people are systematically claiming innocence, right?
Well, actually,
Tell me, did I get that right? Yeah.
you actually don't admit guilt, but you concede
You could,
that the state has enough evidence to convict you.
forgive, I should have put it more precisely. You essentially have to give up your claim of innocence, even if you have really quite plausible legal, so there's a sort of swallowing your tongue aspect to it. And because prosecutors can often say that they will not grant you a way forward, in some cases, it's even just release. I mean, in the kind of cases I've seen that are most heartbreaking, it is if you want to go home to your kids, you have to take the Alfred Doctrine. So now that I've set it up, actually, I would love to hear what you think about it, because you face parole boards, and I think you are a better person to talk about the interaction between claiming your innocence, claiming your guilt, and going forward.
So that's always been a tough subject for me. I always try to understand how do I accept my part in a crime where I did not know somebody else's intention of hurting someone else. I just kept reading the law, and I guess what I told myself, well, this is the law, and I'm guilty. And I kind of just accepted it and kind of just succumbed to it and end up accepting it. I didn't like the fact that I would try to sort of minimize myself in a terrible crime, and I felt like when I did minimize myself that I wasn't taking full culpability. So it was always a struggle for me to try to look at something like that. I didn't want to minimize anything because somebody lost their life, and when I used to think about that, I used to be like, I'm in a no-win position in terms of society, but also with myself, because I'm trying to understand this type of thing. And it was something that was very hard for me. And I used to always ask my, my attorney, I'm like, why am I being held to the same standard of somebody who made the decision to pull a trigger and take someone's life? That wasn't my intention. And I had to stop saying it to myself. I just had to just basically say, this is what it is. This is what society deems you as. Even though you did not commit the murder, you are a murderer. And I just ended up accepting it and just had to move on. If I thought about that for too much, it would have been difficult for me to grow as a person. Because I didn't ever want to try to talk about this to someone else and then look at me and be like, well, you're not taking enough responsibility. So it was very difficult, and to this day, I just end up accepting it, and there's not much I can really make an argument against because, somebody did lose their life.
So I want to just, if I may, give a comment on that as well. So probably all of us in this room, most of us anyway, work in some capacity in the criminal justice system, even if it's to, in our case, teach students how to participate in it and reproduce its members. That system is imperfect, right? We all know that. We all know that it involves compromises every day, right? Compromises between justice and injustice, between what we would like to see it do and, what it's gonna do, right? We all participate in its imperfections. We should all follow Nicholas's example. We should think about whether we need to take Alford, please.
I will also. It is hard to follow or add more to that, but I'll also take moderator's privilege in talking a little bit also about conceptions of innocence when it comes to felony murder. As a person who's been a practicing attorney and counseled clients, I think it is in particular when we have people who are charged with felony murder who either are very young or have cognitive impairments or have mental health limitations or other vulnerabilities that make it very difficult to sort of translate the principles of criminal law into a way that they understand in terms of their own guilt. The availability of the Alford Doctrine in many ways has been a process and a vehicle for getting a client or getting a defendant in a particular case to a point where the balance of risks can play out and a plea can be entered in a way that both sides agree to. But I do think it highlights sort of the challenges when we're talking about felony murder, in particular with vulnerable populations. So. I think we are out of time, so we'll go ahead and move on to our break. Thank you so much to our panelists for taking the time and for sharing. Appreciation to all of you as well.